Good evening. We, the unwilling, led by the unknowing, are doing the impossible for the ungrateful. We have done so much for so long with so little. We are now qualified to do anything with nothing.
I'm ordering you as a condition of your bond not to participate in this kind of behavior.
The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. We will go on the record in the matters 23 CF 189, 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart in person with counsel Nicholas Davis. We're set here today in this matter for two things. One is for a status conference on 24 CF 163, and the other is for a sentencing hearing in 23 CF 189. Mr. Davis, can you please give me a status on the 24 matter before we proceed?
Your Honor, it's not resolved, but may I ask you for a little more patience? I think it has the potential to resolve. I just need another opportunity to speak with District Attorney Schmidt. I'm not asking for that 90-day mumbo jumbo. If I can just have 30 days, Judge, I'd appreciate it.
All right, for that matter, all right. And we are in victims' rights compliance for that matter, yes. Okay. And are we in victims' rights compliance for the 23 case? Yes. Okay. Are we ready to proceed on the 23 matter?
Yes, Your Honor.
Okay. Well, with the 24 matter, Mr. Schmidt, Mr. Davis is asking for additional time to be able to negotiate with you to see if the matter can resolve or if we do need to set the matter for trial. I don't believe that we've had any type of speedy disposition request from either Mr. Stewart or from victims. I do know that victims would like to get the matter resolved as quickly as we can, but not, it hasn't been requested to get it done now, so to speak. So is an additional 30 days objected to?
No, and basically nobody wants to have trials where young children have to testify if they don't have to.
All right, so then that's fine with the 24 matter. So we can go ahead and get that set right now for an additional status and see where we're going to go with that. Mr. Davis, you are coming back on February 10th at 11:30. February 10th at 11:30. We can go ahead and set that at that time.
Yes, Your Honor. Thank you, Your Honor. Your Honor,
What's the date on that?
What?
I missed the date on that.
February 10th at 11:30.
February 10th.
Your Honor, those other two matters, you'll allow me to appear by Zoom. May I appear by Zoom for this, please?
You may.
Thank you.
Okay. Now let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. This is kind of a hard one to do for sentencing, in part because it's a deferred judgment conviction that got revoked for commission of a new crime. The defendant has not been convicted of the new crime. He's presumed innocent of it. Normally what I would say in these cases is I usually go for a probation first when there's revocation of a DJOC, and that's because most of our revocations for DJOCs are for non-payment of fine or them not doing like the programming required on the DJOC. Mr. Stewart's done the programming on this DJOC, so probation, do anger management, DV, that would make sense because he's already done that. I'm going to be asking for some jail time on this, and the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. If you look at CCAP, you see a single forfeiture ticket in Grantsburg for DC. You see Minnesota, some weird misdemeanors for traffic violations regarding equipment violations in a 2008 DUI, and that's it. When I look at it in Protect, though, I see There've been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not in CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. Ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011, 2005, felony child abuse, DPA completed, dismissed. So there is a trend that goes back 20 years, at least to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. But I think because I don't see what probation would do in this case, we're supposed to first consider probation. I don't know what need they would actually address because he's fulfilled the programming requirement of the DJOC. I think that we're really about punishment and we're really about like deterring the behavior. I'm hopeful that getting jail for the first time for this sort of conduct ever might deter his behavior better because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
So I guess I missed, how much did you ask for?
I asked for between 3 and 6 months, Joe.
3 to 6 months. All right. Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. And so you have to look at the convictions, not stuff that was where he did not get convictions or receive convictions, whether it be an ordinance or deferred. Now, Judge, this is a lot different from those other cases, and I'm going to be quite poignant on this. We were prepared to go to trial on this, and the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time, and he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house, and he has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter. And they were working. And he kept telling her, will you start helping? Will you start helping clean up the lumber? And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction, and the board hit her. And he was frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is. Now, yes, he could have tried something different, maybe grounded her or tie him out, but he threw a board, but he did not try to take that board and throw it at her and hit her with it. In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. And then I believe he also had another assessment with, I think, parenting and child parenting, and I believe he completed that. What's really tough right now is that he hasn't had much contact with her and hasn't even had so much as seen her in months, didn't see her for the holidays. And now I believe she's moved from Grantsburg School, Your Honor, where she's always gone, and now she's moved to Pine City School. Her grades are abhorrent. Her grades were not doing well in Grantsburg, but I believe they're even worse now. And so I know that children, they like to make decisions. And I know that if you're under 18, you're a minor, you're a child. And it's a lot easier, Judge, I know you've seen this, to be with a parent that gives you the freedom, the video games, that can do whatever you want, and all these things. And yeah, that's nice. And sometimes the parents migrate towards that. And sometimes the parent that has homework time, we sit down for dinner together. You need to help me with some of these projects around the house, and you have chores. Yeah, that's not the fun parent. I know that. I had two parents like that, and there's always a chores, or there's always something. And when I'd see my friends playing or skateboarding or swimming, and I'd have to do these things, yeah, I thought I had the worst parents in the world. But looking back, I didn't. I had parents that cared enough to want to see me have some structure and succeed. What I'm getting at is he's got this criminal conviction for misdemeanor battery, and his daughter was involved in this. And again, he took a piece of lumber and he was upset with her. But I just want you to know, Judge, he did not throw that to hit her with it. He was, get going, get your butt moving here, help me out. So, Your Honor, he does work. He makes all his child support payments. He does whatever he can to support his daughter. Strike that. I don't know if there are, I'm going to strike that, the child support payments. I don't know enough
No,
about.
I know that. And I saw him say, no, he doesn't.
Well, and I don't know, I don't do family law anymore, and I'm certainly not representing him in this family law case. And I think there's something going right now currently with that. But so I'm not representing him on that. But I do know that when it comes to any extracurricular, or if there's clothing or whatever it needs, she's not denied any of that. And quite frankly, he's going through, I think, hell right now because he can't talk to her. I don't think the mother's allowing him to speak to her. And quite frankly, I don't think there's any order of this court that denies him that contact. I think if he is to be around her, it's got to be with someone supervised or someone 100% there with eye contact around him. I think that's my understanding with any 18-year-old or younger. But in any event, he's still being denied that access. And so I don't, again, I understand, is this a serious offense? Yes. What is the character of the defendant and his rehabilitative needs? I think his character is strong. I think he did everything he could to follow the deferred. Again, he's got another charge pending, but he does enjoy the presumption of innocence. And that case, again, is not resolved. And I don't want to go any further into that because there's really no reason. It's the presumption of innocence, but it's because of that case is the catalyst, and it did not involve his daughter. It's because of that case we're here for this. And it had not been for that, I know he would have successfully completed this agreement. So what's the need to protect the public? Well, now he's not around his daughter. And it's basically just him and working, but he's not an alcoholic. He's not a drug user. He's a hardworking man, pays his taxes and supports anything he can with regard to his daughter's success. And so, Your Honor, the only thing that I can think of is I know anger management, I understand what it is, I understand what the assessment is, but sometimes I think the domestic violence assessment, which is much different, and usually that entails fall through, and also entails that the therapist needs to see the criminal complaint and as much documents as they can see. And I think sometimes that assessment may be something that may be more forthcoming or can see if there is any issues there, because it was his daughter, and they are in a domestic relationships and the definition of it. So I think that assessment, I think it's much more in depth. And I think the anger management assessment, while it's good and it can assist, I think that the domestic violence, I think it not only covers anger management, I think it covers a whole litany of things with regard to being a father and how you act. And yes, if you get frustrated also, I think you get frustrated, you don't throw lumber or although I've had many times growing up where maybe my father wasn't right, but I certainly had things like that happen as well, where he was,
And that wasn't right, Mr. Davis.
Well-
That was abuse.
no, I love my father and it made me a very successful person. He never hit me, but he would say, get going, pick it up. He never hit or hit me with any lumber or anything, but he was very hard on me. And I know my father never abused me and he's a wonderful, wonderful father. But what I'm getting at is he was hard on me. And I think that created a lot of my success. And so I thank him for that. Now, again, this situation, had it been handled differently, maybe he pulled his daughter aside, but I think where his head's at, I really want the court to know this, his head was not to be mean to her, not to hurt her, but he wants her to be successful and have some structure. And again, I don't know anything about the mom. I don't know, but all I know is I don't think there's the same structure there as it is when it's at dad's house. And so he's the mean parent or the bad parent because of that. In any event, Your Honor, I'm asking the court to consider probation. And this is a heavy duty. My client and I discussed this, but I think it should be probation with an imposed and stayed for the whole time. And he completed domestic violence assessment and he follow through. And that way the ball's in his court. So if anything should happen for the term of probation, then he doesn't, not 3 months, not 4 months, but the whole entire deal. I'd ask the court to consider, because he is full-time employed, that he would be allowed Huber. But I think that's a heavy hit. Put it on him, put the anvil on him, and that's an imposed and stayed for the entire time. Thank you very much.
Thank you. Ms. Bauer, do we have any victim impact statements? I have nothing in the file, so I don't know if anyone's going to make a statement. No, Your Honor.
I received nothing in terms of that.
Is this the victim in the courtroom? No, this involves a different matter? Yeah. All right, okay. Okay. Mr. Stewart, I am now going to turn this over to you. This is going to be your opportunity for you to provide me with any statement that you wish to provide me with. And let me know anything that you wish to let me know as it relates to this matter and any other matter or any other thing that you want me to know and understand. You don't have to, but it's your only opportunity.
I don't know.
You don't have to.
You don't have to, but if you want to tell the judge anything now, this is your right to do that.
I don't know what's going on.
All right. Mr. Davis, I fully understand where you're going with, where you were coming from with your argument. And I fully get, and when you were telling your story of how you grew up, Mr. Davis, I get it and I understand. I too had very strict parents. I too had a father that was very strict. I too had a father that was very much like Mr. Stewart, not like your father, Mr. Davis. Not like, if I am going to guess 100%, Mr. Davis, your father did not throw a board at you.
No.
I don't know if your father was angry and your father threw things when he was angry, but it's not okay. It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. Even if you had zero intent to hit your daughter, that is abuse. It is abuse. It causes emotional trauma within your child to see you act like an idiot, like a jerk, like even more words that I cannot even say on the record. You were an awful parent that day. And if I read from the criminal complaint of what happened that day and how it went down, the officer responded to the address and made contact with Ben Stewart in the front seat of a pickup with juvenile 1 sitting on the passenger side of the truck. Ben told me he was taking juvenile 1 to get checked out at Burnett Medical Center. I had juvenile victim 1 get out of the truck and talk to her. Juvenile victim 1 was crying. She told me that her dad, Chris, had told her to use the tape measure when they were working in the yard. Juvenile victim 1 had gotten dirt in the tape measure, and Chris had told her that if she did that, she would not be going deer hunting. Juvenile victim 1 then was upset and told Chris that she was going deer hunting with her uncle, Ben Stewart, and he would be taking her. Chris then threw a board at her, which hit her in her arm. Juvenile victim 1 showed me her forearm, and I could see a mark on her arm where the board had hit her, and a bruise was starting to form. Okay? And then it goes on and says that he threw the board during the argument, but didn't mean to hit juvenile 1. That's what you told the deputy. He thought she would, quote, get out of the way, quote. You thought she would, quote, get out of the way, quote. When you threw a board at her, you hoped you thought she would get out of the way. When you were mad that she got dirt in the tape measure, and now you said, nope, sorry, I'm taking away your pleasure of going deer hunting, which is great to teach a young lady, by the way. And you said, nope, I'm taking away your fun. You're no longer going deer hunting because you got dirt in my tape measure, because I love my tools, because that's what I do. And so I got mad. No, you're not going deer hunting. And then she said, no, Dad. In parentheses, I may not be going deer hunting with you, Dad. I'm going deer hunting with my uncle. And I'm going to presume uncle's your brother, Ben, because Ben at that time, I'm guessing, was siding with juvenile 1. Because how it laid down here is you thought she would get out of the way. You don't get angry over things like dirt in a tape measure. It's not like she was not picking up the lumber. It's not like she wasn't doing her homework. It's not like she wasn't cleaning up her room. She got dirt in the tape measure. And you got upset when she wasn't listening because you were trying to take something of pleasure away from her. And she said, no, Dad, too bad. So you threw a board at her. And your excuse was, I thought she'd get out of the way. But she didn't. Because you know what? A man throwing a board, a heavy, I'm going to guess 2x4, goes fast. If you've ever taken science class or a calculus class or anything like that, and you do all of those mathematical formulations, they go pretty fast. Okay. It's kind of hard for, I think, a 15-year-old, if I'm recalling correctly, to get out of the way. That's rage. That's not a good parent, Mr. Stewart. That's not a good parent at all. That causes trauma that she will have to live with, and she will have to try and figure out throughout her entire life how to resolve. With or without having you in her life. Trying to build boundaries with having you as her father, because she doesn't get to choose. She didn't get to have that choice of, God, let me see, who do I want to have my father? Should I be born to, someone famous or Christopher Stewart? I'll choose Christopher Stewart. She didn't get that choice. And I'm not sure if you even truly comprehend and understand your actions that day. Because I'm going to tell you, that's not the first time that has ever happened. I'm guaranteeing you that. I'm guaranteeing that is not the first time you've reacted that way. I'm guaranteeing you that. You know that. I'm sure Mr. Davis knows that. You're acting like you're confused, like that was the first time you've ever acted that way.
First time I guess I've thrown anything.
I don't believe that. I highly don't believe that. I don't. If your anger and your boiling of emotion and frustration got to that level where as Mr. Davis said, your head wasn't right that day, but your head was so explosive that day over dirt in a tape measure. And your daughter saying, no, Dad, Ben's going to take me hunting.
I've always taken her hunting too, but
Correct, but that's not the issue. The issue is not who's taking your daughter hunting that day. The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. You reacted, you took what you had, the board in your hand, you took that, you used that as a weapon, you gained control by taking that board and throwing it at your daughter. I guess thinking, I thought she'd get out of the way.
I've threatened to take the cell phone away, but that doesn't work either, so.
Oh, so what, did you try to throw a chair at her that time? Okay,
No,
so
she just, I take it away and say you're gonna do dishes. That was another time. She just goes next door to her aunt's house, calls her mom. Then I'm an asshole for taking the phone away. Sorry about my language, but then so I can't win at any of this. I've tried. I don't know how to shut the phone off. I pay for it, but I don't know anything about them.
well, that's not the issue. And here's the thing, what you're trying to do. You're trying to control this situation right now. You're trying to divert this situation of what happened this day, your conduct, your behavior, to throw it back to the other times you weren't able to parent. I don't know. And that doesn't matter here nor there. Here nor there. Today is why you threw a board at your daughter. Why you let your emotions and your anger explode to throw a physical object, a weapon at your daughter that day. Now, do I believe that this does deserve a punishment? Yes, I do. But I do believe that there are other matters in the 24CF case that we need to figure out first, because those are very serious as well. Right now, you're not having contact with your daughter, which is probably a good thing. I can't help her, and I can't order that she get trauma-informed therapy, which she needs. She needs. But what I can order here, I can't do it if I put you in jail right now and I do a straight jail sentence. But what I can do, at least in the meantime of while they're figuring out this 24 case, I can order a whole lot of other things that you do right now. And I can make sure that they're done while we're figuring out what's happening in the 24 case. Because there's a whole lot of things other than anger management and parenting classes and stuff. Those are great. Those are grand. Those are wonderful. Those are not enough. Those are not enough for me to determine whether or not you go and have a full psychological evaluation, that you get evaluated for an in-depth evaluation for narcissism, whether you're a narcissist, whether or not you have a full evaluation of your total mental health, of getting down to all of the nitty gritty of Mr. Stewart and doing all kinds of other things. Because that's what my focus is on right now. I could punish you here today and I could send you to jail for 9 months here today. That's not going to accomplish anything but punishment. And that's not going to do anything in the meantime right now while I'm giving Mr. Schmidt and Mr. Davis time to figure out what's happening in the 24 case. Because I don't know what's going on there. I don't know the facts there. I don't know any of the in-depth there. I don't know what's going on, but I know what's going on here. And I can see here that there's a lot of work that Mr. Stewart needs to do. A full lot of work that you need to do. And I want it done, and I want it done now. So, Mr. Davis, you win. I agree with your argument. Well, not your argument necessarily, but your recommendation. So, at least at this juncture, and at least at this point with this case, I will place you on probation for 1 year. Imposed and stayed jail 9 months, consecutive to any other sentence.
What that means.
Any other sentence that you may now have or may have in the future.
Your Honor, can you explain to my client what that imposed and stayed means? I don't think
Yeah.
he fully got it when I explained it to him.
All right. So an imposed and stayed jail sentence means I will place you on probation. That means you will be on probation for a period of 1 year with certain conditions that I will lay out for you bit by bit, word for word, so you can understand them. If you fail to accomplish my conditions, you violate probation, you will be revoked. If you are revoked, you don't come back in front of me for sentencing. You will immediately go to jail and sit 9 months of jail, okay? So it means you must follow what I'm telling you to the letter, to the T. Do everything that I'm telling you you must do. All right? Okay? Is that a yes? You understand?
Yeah, yes.
Okay. Now, Ms. Bauer, I don't see any restitution. Is victim going through any type of counseling? That's my knowledge. I am going to hold open restitution, a hearing for restitution for 45 days so that you can follow up to see if she is doing any counseling or any trauma-informed counseling, because I would like to know that, and I'm sure Mr. Davis would like, or Mr. Davis and Mr. Stewart would like to know that. And if she is, and if that's a possibility, please let the court know and we will schedule a hearing, okay? Yeah. All right. So probation, 1 year, 9 months imposed and stayed, again, consecutive to any and all sentences. The court is going to order $1,000 fines, fees, DNA surcharges, all wrapped up in one little bow. Conditions of, you have $250 posted. That means you still have $750 left to pay. That will be paid, that will be due within 30 days to the court here, not to probation. Conditions of probation. 1 is to have a full spectrum, complete mental health, psych evaluation. Absolute sobriety. A full psychological evaluation which would include a determination of whether or not there's narcissistic personality disorder, any anger disorders, any personality disorders. Again, the absolute sobriety, that means no alcohol, no illegal drugs, no bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. No casinos.
I don't go there.
I am ordering an abuser intervention program treatment. That is a program that's designated to rehabilitate those who repeatedly use violence towards intimate partners or family. Because as it was stated, and yes, I understand, Mr. Davis, your argument that it may not be used for conviction purposes, and the court should not use that in punishment purposes, which I didn't. I didn't send him to jail. However, there is a history here of at least charges as it relates to domestic abuse or domestic abuse enhancers, and they've been reduced to either ordinances and or deferred prosecution agreements or deferred judgment of conviction. Therefore, you must do an abuser intervention program that is designed to rehabilitate or focus on individuals that repeatedly use violence and other actions towards intimate partners and or family members. Gainful employment, we don't have to worry about that, but it is one. No abusive contact with your daughter, but no physical contact unless approved by agent or court. And I don't know what's going on with your child support, but make your child support payments.
Oh.
I don't follow up. I don't keep to follow up, but you're not going to tell me what's going on now. I'm just going to say that's a condition. Pay your child support. Keep it up to date. That means you must go and talk to child support and figure that out. If you fail to pay your fines and fees within 30 days, not only will the court enter a civil judgment against you, I will issue a warrant. You will sit 6 months in jail separately from this 9 months that's been imposed and stayed as for contempt for failing to pay. Very important you pay, okay? All right. What am I missing, Mr. Schmidt?
Nothing from me.
Mr. Davis.
Your Honor, I think he may have one. I know he has 1, maybe 2 days of credit. I'm just not certain.
I'll just put 2 days. I'll give him the benefit of the doubt. 2 days jail credit.
He said he sat overnight, but I don't know if he got in before the midnight hour. I just don't know. So I just want to make sure that I'm not saying I just don't know for sure.
I'm good with 2 days. 2 days is good. So what I'm expecting then on the other cases, we'll have a status in February. I'm not expecting, and I'm not saying that it must be resolved by that February date. This is a very serious case, but I want the victims be able to be assured that it is working towards either a resolution or that we're going to be able to set the matter for trial so that we know where this is going. If we need another status, Mr. Davis, after that February date, I'm fine with that as long as the victims are aware of what is going on.
Your Honor, may I ask a question, please?
Yes.
So I understand what your order is with regard to the bond conditions, but he'll have to wait till he meets with the agent with regard to how that, or if there's any contact with his daughter, correct?
He can, I'm fine if he has telephone contact.
I'll talk to him. I just want to be very careful. She may not want to talk to him too. So but again, I just want to make sure that he follows the rules. And then the other thing, Your Honor, with the abuser intervention, is there a specific place that the court uses here in Burnett County, or can we use any different county for that?
No, I'm not, there is not one in Burnett County. I am not quite sure of if there is exactly one that is used by DOC or not.
See, so they'll probably, I do know that the psych evaluation, I know there's people that do
I was
that.
looking at Wisconsin DOC when I was looking at that, the primary treatment programs that they have. I was looking at their website when I was saying it.
So we should let the agent set that up then.
Yes.
Okay, all right. All right, understood. But so nothing, I'll go through the post-conviction, nothing further, Your Honor.
All right, so 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must provide your DNA. Failing to provide that, well, you're going to, because you must go report to the jail right now, provide your DNA. Once you're done providing your DNA, you must go report to probation, get all of that set up immediately. This may be something, but I don't know if it is, but it may be a crime that you would be able to have your DNA expunged, but it would need to be a written letter to the Department of Justice, but you would need to do it to the Department of Justice, not to Burnett County. It's easy to do. You can Google it or ask Mr. Davis. Now, I believe that does cover everything, Mr. Schmidt.
So the court said a few things about contact with his daughter.
No abusive contact. He can
Yes.
have telephone contact, no physical contact without agent approval.
Well, I'm just wondering because of the bond in the other case.
That just says no victim. That applies to the victim of that matter.
But it also says no contact with minors under the age of 18 without full eye supervision. I don't know what full eye supervision means.
It means you have to be in the same room and look at them at all times.
Because the other component of that is, of course, his daughter is a witness against him in that case. She is juvenile witness 1.
Well, it doesn't say, that bond does not say no contact with witnesses. And the
Okay.
state did not ask to have no contact with witnesses. So if you're going to be asking to modify that bond to have no contact with daughter, that would be for the state to motion the court to modify that bond.
To be blunt, I thought the no contact with minors under 18 already covered it.
Does
So-
not.
Okay. We'll file something in that case then.
Well, we're here today, so
That's true. I would ask no contact with his daughter in 24 CF 163 as a condition of bond.
until it's resolved,
Yes.
Mr. Davis.
Well, Your Honor, I would ask for time to prepare for this motion.
Well, what I'm gonna say is there could be no contact with his daughter about the matter specifically relating to 24 CF 163. Ms. Bauer,
The last time I spoke with the victim, she did not want to have contact.
daughter? Well, and she can
She's-
refuse contact all she wants, but I will modify bond that says no. In 24 CF 163, no contact with daughter, or no communication with daughter concerning the facts of this case.
And I will tell him that he'd be insane to do that because he could wind up with more felony charges by doing that.
Can I send a birthday card, Christmas card? I mean, I have it all at home.
Yes.
Just, can I do it or not?
I'm not saying no contact. She can refuse it.
You saw the bond, so
I'm just trying to make sure it's clear because I've been waiting for these answers for a long time.
And if she further wants no contact, Ms. Bauer, that would need to be a specific motion because I've never heard that prior to just now.
I don't know. Anyways, yes, and Your Honor, so he will not mention anything about the case. And she, like you said, she may not want to have contact, and he understands that if he does have contact with her, there's got to be 24/7 eyeballs there of an adult seeing that contact.
Correct.
So yes, he understands that.
All right, anything, but you do understand that she can refuse any contact. Like if she doesn't want that birthday card, she can say refuse, return to sender. Or she can go click, send a voicemail, or she can block, or whatever she wants to do. That's her choice. There is no court order, at least that I'm aware of right now in the family matter, that says that she must have contact with you.
Thank you, Your Honor. Nothing further from the defense.
All right, then we are adjourned. Thank you.
About time. That was, I think, the longest one I've seen of her. But thinking about that the other day, I saw a 6-hour contempt hearing that she had with a guy, and it was very personal with him. She was raising all kinds of hell with him. I really wanted to show it, but I missed recording some of it. But it was, like I said, it was 6 hours for a contempt hearing, and it was drug out, but it was interesting. It's fun to watch her get mad and just start raising hell with somebody. But yeah, this guy certainly's got a temper issue. I could see throwing a board at my son. I couldn't see throwing a board at my daughter for any reason whatsoever. Now, I wouldn't want to hit my son with the board, but sometimes you just got to get their attention. But we're going to jump over to Judge McNally. He had some good ones. This one's from actually this morning. I picked up on it. Someone was suing the city over a wedding. So let's see where that goes.
Good morning, Your Honor. Michael A. Carmen, P7384, on behalf of the plaintiff.
Good morning. Mr. Zick?
Good morning, Your Honor. Matthew Zick for the City of Flat Rock.
What's this case about, Mr. Carmen?
Your Honor, this was a case where my client got married at the Flat Rock Community Center, and basically the city breached its obligations under the contract in a number of ways, including certain, the behavior of certain employees. And my client, on her wedding day, did not get the benefit of her bargain, to say the least, and basically ended up having to clean up the hall herself in her wedding dress. So you could say it was the wedding from hell.
Well, that's too bad.
Yeah, I felt
Okay.
terrible for her, genuinely.
All right. Did you guys talk about this, Mr. Zick?
We've had some preliminary discussions and we've talked about possibly going to facilitative mediation with it.
Nobody demanded a jury, right?
No,
The
Your
city
Honor.
didn't.
How much did you sue for, Mr. Carmen?
Your Honor, we pled emotional distress. So the amount we're suing for is $24,999. Actual damages are close to $12,000 and change.
Yes.
And I've itemized those in the complaint.
Boy, it's too bad. I know I could help you settle this, but I can't do it if I'm going to be the fact finder, unfortunately. So I'm going to do the same thing. I'm going to give you a discovery cutoff of April the 10th, witness list due March the 10th. Same thing here, gentlemen. Discovery permitted. No, I'm sorry, no motions on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Again, witness lists are due on March the 10th. Discovery cutoff April 10th. Trial date May the 20th at 10 a.m. Is there anything else that you need to bring up, either one of you, Mr. Carmen or Mr. Zick?
Nothing for me, Your Honor.
Your Honor, not at this time. If Mr. Zick and I do agree on facilitated mediation, how do we go about?
Are you guys talking about hiring your own independent facilitator, or are you talking about going through ADR through the court? I haven't used that through the court in quite some time.
Was talking, Your Honor, about going through an independent hired facilitator since you're the fact finder and we can't go through you. So
Right. Well, we could do it ADR. You could try ADR by calling the civil department. I hate to see you guys spend that kind of money on a facilitator on such a small case, but
that
so
would be my preference.
The
What
city
would be?
prefers, I apologize, Your Honor.
That's okay.
The city would
City
prefer
pre-
not to use, they have not found that, that to be resolution, or something, that would be adequate. So I'd prefer to use a facilitative mediator we hire.
Well, that's up to you guys. I'm not ordering that. If that's what
Okay.
you choose to do, that's fine. If you want to use ADR, it's only $75. I get it. It's up to you, but those facilities, whatever, I'm not gonna.
Yeah, I believe you get what you pay for, Your Honor.
Okay, well, all right, I'm not ordering it. You guys do what you want. Otherwise, just stick with these schedules and your trial date will be on May the 20th, okay? Have a great one,
Thank you so much, Your
gentlemen.
Honor.
Thank you.
Will do, Your Honor.
Thank you.
Thank you.
LENV versus Bush, Terry Bush, 2-404574.
Hello again, Your Honor. Keith Sparks here on behalf of the plaintiff.
All right. P number again, Mr. Sparks.
Sorry, P77485.
I'm trying to think, somebody didn't show from your office last week. I don't know what's going on, but we called and they put me on hold. I called. They put me on hold and I finally hung up. Anyway.
I do apologize for that, Your Honor.
You don't have to apologize. I'm just pointing it out. Is Jennifer Palin here? She was not, the reason I recall that, she was on the case last week and didn't show up. I don't know what's going on over there. Do we have Linda, call and tell John, just for everybody's edification, I can't hear her, she can hear me. Would you call John and tell him whether or not you see Jennifer Palin out there? Do you have a lot of dealings with this lawyer, your office, Mr. Sparks?
We do have quite a few hearings with her, Your Honor, and so we do get most of them resolved.
Is it common practice for her not to show up? I mean, we make this so convenient now. You can sit in your living room, and I'm just curious as to why I have to call lawyers. And frankly, whether you want one or not, I'm entering a default if she's not here today. I'm not going to be chasing lawyers around. I rescheduled this one once, the one I'm referring to last week, because she didn't show up. And then I rescheduled it and nobody showed up and I dismissed it. So I don't know if they're just not bothering to tell us or it's just too much of an inconvenience for somebody to get on Zoom. It's possible, it's possible. I kind of like, I stayed up late and watched the Super Bowl. I'd have loved to have been sitting in my family room right now drinking coffee, but I can't do that. I have to come in here. So unless somebody can tell me why, I'm going to enter a default here. Is she here, Linda? You gotten this lax in this profession, ladies and gentlemen, where we don't bother showing up for court. We've made it so incredibly convenient. I sometimes think I'm going to be conducting court on people's boats and on the golf course and in their backyard, and they can't even get on Zoom. It's ridiculous. But I don't think she's here. Is she here?
Oh, you didn't hear nothing. Okay, I'll
Nothing? Default judgment, counsel.
Thank you,
Defense attorney failed to appear. I'm entering a default judgment. Give me your breakdown.
The breakdown for Terry Bush is the balance of $1,725.30 with court costs of $55 filing fee and a $55.26 service fee.
All right, and is that it? So you got 110.26 in court costs, right?
Correct, and then a balance of 1,000. Oh, sorry.
You're not asking for the statutory attorney fee?
We are not, Your Honor.
1830, 556, right, is your total?
That is what I get as well.
I'm gonna be clear about this. I want you to submit a default judgment right now. And do not stipulate to set aside this default judgment, okay?
Yes,
If
Your Honor.
Ms. Palin's gonna do this, she's gonna get to come in and talk to me. I don't know what's going on. She's 0 for 3. They pay you nothing in the major leagues to go 0 for 3. That's it. Default judgment, submit it, please. Thank you. Have a great day.
All right, I love how the judge told him don't stipulate, don't allow it to be set aside. You win the default judgment. He's tired of her not showing up for court, so that was fun to watch him get frustrated there. Saw Victoria in court today. Judge slipped up and said she was right once, and she had to call him out on it and made the whole judge laugh. And so let's look at let's go to Judge Garcia. She had a little landlord hearing. Let's go there real quick.
All right, Nationwide, go ahead and get it started. What is the monthly rent?
Yes, Your Honor, this is for non-payment of rent. Monthly rent is $1,269. There are no subsidies. Defendants owe September through December, prorated through today's date. That's a total of $4,210, and that's strictly rent.
Miss Williams, first of all, do you agree that your base monthly rent is $12.96 a month?
No, ma'am.
Okay, do you have your lease?
No, ma'am.
Nationwide, do you have your lease?
Yes, and I'm sorry if I misspoke. It's $12.69, Your Honor.
Yes, that's what I have down, but she's saying it's not.
Okay, let me screen share this one.
Okay, so there's your lease up there. The amount of rent is $12.69.
I have never seen the lease before.
Can I see a signature?
I've signed it, yes, but I don't have that.
Okay, so then I have to go by what the lease says. Okay, and you're locked in at $12.69. With
I
a signature.
understand, but I have no idea of this document because I don't have it. I signed it, yes, but I don't have it in order for me to get help. I've been asking for it since July.
Okay, I understand, ma'am.
And this property's been stealing money and everything else from people on there. I have got a violation against my safety rights because I've signed an EARP paper too.
I need you to calm down first.
I'm
okay?
sorry.
Yes, but you're not getting nowhere doing this.
They're
so
doing
calm
too
down.
much, man.
Okay, so the monthly rent is $12.69. That's all I can do. I have a written lease with a signature. So, Miss Williams, did you pay September through December?
No.
Okay, why not?
Because of the property themselves. They don't talk to nobody. They won't answer my calls. They won't answer my emails. They won't speak to me when I walked in the office. They're rude. They're obnoxious.
So you just decide not to pay rent since it's
how am I supposed to talk to anybody to pay rent? They won't even accept partial payments. I can't even get a document to go pay at Walmart.
Nobody accepts partial payments.
I understand that, but what am I supposed to do if they're not willing to work
So they
with
never
me?
told you how to make a payment, ever? They just gave you
I
keys?
asked for a new paper for me to go and pay at Walmart because they got people stealing our money orders.
Okay, so have you made a money order that they've stolen?
Not in a while, no, because they stopped it after they stole everyone else's.
Okay, so as of right now,
But I have
September?
money towards it. I just don't have the full amount.
Okay, so you do agree that nothing has been paid since September?
No. Yes, ma'am. I do agree.
Okay. And you do realize that I have to proceed forward whether there's frauds or not, because you have already admitted you haven't paid since September and you can't stay there for free.
I understand that.
Okay. And so right now, what is it that you can offer them? I understand you have a pending case. And
right now in my pocket, I have $400 and that's all I have as of right now, but I get paid every Friday. So I have no problem paying.
Okay.
But I just want this property to foresee better judgment on people.
So Nationwide, is this property interested in government assistance?
Your Honor, they do want to proceed with judgment today. They don't accept partial payments. So if she does receive any rental assistance, it'd have to cover the full balance or she would have to pay the remainder.
Okay. And okay.
If assistance is willing to help with even half of it, then I can sure come up with the rest.
Okay. And just from experience, if they're not willing to give you a copy of their lease or anything, then they're not interested in government assistance. I can tell you that right off the bat.
They're not willing to help anybody on that property, ma'am. And they've been going through this for years.
And ma'am, I can't force them to
I
accept
understand
any
that,
government
But
assistance.
they're all over the news. Do you understand what they're putting our families through, my babies through?
Then you can go hire an attorney and you can file whatever lawsuit you feel is necessary for them.
Like, y'all, they place an EARP paper for protection against my ex-husband, and they're still doing this to me.
I don't know.
I
what's-
filed housing papers when I filed my lease. I filed housing papers and it have been pending for a while, and they still ain't doing nothing.
Then the only thing I can tell you, ma'am, is to hire an attorney.
Who can afford that?
Or-
I just came from one eviction in a hotel to another crappy ass apartment complex that's doing me this way too.
And well, we have legal aid out there as well that's legal based, that's income based. But ma'am, as far as I can't give you any advice on the bench. All I can tell you is to contact an attorney or file your own
People
lawsuit.
shouldn't be allowed to treat people this way.
Judgment's going to be in the amount of 4210. You do have
And
5.
I don't even owe that amount at all. I know I can tell you that for a fact because they dumped a whole bunch of charges on me.
So I just asked you if you agreed to that amount and you said yes. So
5,000, yes. The rest of it that they say I owe, I don't.
your judgment's only for 4210.
Well, it's still wrong.
Okay.
Thank you, Your Honor.
Have a great day.
Well, that was a short and quick one. Judge wasn't listening to her, and the lady wasn't listening either. So that solved that one. I'm gonna throw another Judge McNally up, and let's see. I'm gonna throw another Judge McNally one up.
People against Austin.
Right to the podium here.
Mark Charles John Austin, 242-643-179. Everybody's name?
Thank you, Judge. House Counsel Michael Baldwin, P. 65417, on behalf of my client, Mr. Mark.
Name, sir?
I'm sorry?
Your name?
Oh, Mark Austin.
This is going to be a plea. They're going to dismiss the super drunk and he's going to plead to impaired.
Yes, Judge.
You did a great job on
Thank
this
you,
one.
Judge.
If you plead guilty to operating while impaired, possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those 4 points. License suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
I do.
How much had you consumed before you drove that vehicle on that date?
More than I thought I did.
Well, that isn't good.
Yeah.
I don't know what that means. What were you drinking?
Twisted teas.
How many of those did you have?
Well, I had a couple of shots of liquor, but also it was mostly twisted teas.
How many?
5 or 6.
His body weight.
Hang on a second.
He's good.
You're not going to tell me you had 5 or 6 twisted teas and 2 shots of alcohol, are you really?
No, I think I had more, is what I'm saying. But
do you remember how much you had?
I don't.
Is it possible you had somewhere in the neighborhood of 15 twisted teas or 20?
It's possible, yes.
When you were operating the vehicle, what happened?
So I was operating the vehicle.
This ticket says you struck 2 parked cars. Is that true?
That is true. Well, I'm not entirely sure. I was in a bit of a confusion.
Your Honor, we could, if the prosecution would be amenable, we could amend this to a no contest plea for lack of mental recollection based upon mediation. He did blow.
I know he did.
Yeah.
That's why I'm hearing this 2 twisted teas.
Your Honor, can we
get the city attorney in here for me, will you please?
It's the same as a guilty plea, but he doesn't listen. He doesn't have to establish a factual basis. He can read the police report for himself and establish the factual basis.
Do you remember what happened?
Sir, I remember leaving my friend's house, and I remember the impact of the
I need the
vehicles.
police report too. Go ahead, I'm listening.
I remember leaving my friend's house and I remember the impact of the vehicles. The airbags went off. There was smoke. There was
Dust.
Yeah.
Ultimately, were you arrested?
I was, yes.
Were you administered a breathalyzer test?
I was administered a field sobriety test, and then I refused to do that because I felt that it was unnecessary. So I did breathalyze.
All right. You did the breathalyzer at the police station?
And the PDT.
I did.
And were the results at the police station 0.36?
Yes.
You stipulate that was an accurate reading for purposes of the plea?
Yes, both results based on the intoxilizer 9,000. Yeah.
Are you on probation or parole?
Not at this moment, no.
Anybody force you to plead guilty?
No.
Makes sense. Okay.
I got to tell you something. 30 years I've been here. This is one of the top 10 to 15 highest blood or breath results I've seen in my career.
We looked it up, Judge. It's beyond death. There's a death and then there's one after it.
What are you doing? You didn't have 5, 6 twisted teas. I don't even know what a twisted tea is. They got so many different types of alcohol out there now. I don't even know what one of those is.
Iced tea beer.
Okay.
Iced tea beer.
Yeah, it's like alcoholic tea, like a Long Island iced tea, but in a little can.
Do we need to do a no contest?
No, I'm satisfied.
Yeah, thank you, Judge.
I'll accept the plea.
Thank you, Judge.
I'm just stunned that you were driving a car with 4.5 times the legal limit. I mean, you got a drinking problem, sir. I think you probably need our sobriety court to tell you the truth. And I'd encourage you to talk to him about it. I'm giving you a $2,500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with the victims or prosecution witnesses. You're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. You're going to go to AA at least 4 times a week. You're not to be on a SoberLink device by the end of the day at your expense. Now, we have a sobriety court. I mean, you're going to die. You keep doing this. You're only 22 years old, right?
Yes, sir.
You know how high this result is?
They informed me of that. Yes.
I think you need sobriety court, young man, or you're gonna ruin your life. I'm gonna let you talk to probation. Take him over there.
Yes, Judge, I will.
Tell him what I said.
Yes, Judge.
Have him talk to Ms. Tessino.
Yes.
I'm ordering a screening and assessment. I'm gonna give you a sentence date.
I want to lay a little bit of a foundation. He doesn't have a car anymore. His concerns about probation have been noted. So he wants to make sure that he's not setting himself up.
All right. Do you work?
It's not entirely stable.
Where do you work?
I do like under the table kind of like construction stuff.
Why don't you get a job?
I've tried, I've applied.
Did you graduate?
I did.
There are all kinds of jobs out there. I mean, if I took my law degree away, my college degree away, I could have a job by noon. It's 11. What is it? 5 to 11. I think you're spending too much time sitting home drinking. Find a job.
I mean,
but I'm not going to listen to this as an excuse. Listen to me very carefully. You are going to die if you don't get yourself some help. I mean, this is stunning to see a 22-year-old man in here with a 3.6. It's stunning. You need to figure out a way to get here so we can get you some help. I'm just shocked what I've seen, but I can help you. We can help you, but you got to want to have help. You need sobriety court right now before it's too late. I'm telling you, when I see young kids with these types of elevated blood results or breath results, They don't just come in and out of the criminal justice system. They remain here until something really bad happens. And they end up in prison or jail for a long time, or accumulate such a record that they can't get a job salting fries at McDonald's.
I see.
I'm not trying to make you feel bad. There's nobody else in here, but.
Well, I should feel bad.
Yeah, you should feel bad.
And I do.
SoberLink, by the end of the day, please talk to them. I want them to talk to him about sobriety court. We want to help you.
Thank you.
But you got to get a car. You got to be able to have transportation to get to testing. You got to be able to have a car to get to AA, to outpatient treatment, to meet with probation every week, to come and see me on status reviews every other week.
I think it's also important to note, because the prosecution was so generous, he has 3 months restricted with no hard suspension. So in essence, he has a driving.
Too generous, in my opinion, but I try not to get involved.
Yes, Judge.
I'm good with it. I'm fine with it.
So he has a license.
But he's going to have to earn this.
Yes, Judge, we understand. Thank you very much.
Thank you, sir. SoberLink device by the end of the day. And don't tell me you don't have the money. You need to get a job. You need to straighten out your life. You drove into 2 cars, parked. You had no business getting behind the wheel.
No, I didn't.
All right. Now, that being said, I'm not your enemy here.
No, I know you're just, upholding the law.
No, it's not that. I want you to understand how concerned I am about you. I really am. I mean, this is bad enough for somebody to have that. Okay, go talk about sobriety court. SoberLink, end of the day, even if you decide not to get into sobriety court, you have to have one by the end of the day. Oh yeah, give me this. I'm just stunned here. Still, forgot to even get a sentencing date, Lisa.
All right, so this guy with 0.36, it took 10 minutes for the judge to be done with him. Compare that to Judge Mogan earlier. It took 40 minutes for her to deal with that guy that just threw a board at his kid. Now, I agree hitting 2 parked cars is not like hitting your daughter with a board, but in the end, the daughter didn't go to the hospital. Dad was being an ass. Dad got what he deserved, but in the end, she didn't get really hurt that bad. So, but this guy here, 0.36, those 2 cars could have been anybody's family out there. But Judge McNally got done with him in 10 minutes. I like that.
She's not out there, is she? She probably got tired of hearing me. Right. I'm going to give you a sentence date in a couple weeks. Mr. Baldwin, you're here on the 13th, right?
That's good.
Bryce Allen Dairy, 24T643522. Good morning, Mr.
Good morning, Your Honor. Evan Callahan appearing on behalf of the defendant who stands to my right.
Sir, your name?
Bryce Dairy.
All right, so your client previously pled guilty to the charge of operating while visibly impaired. The super drunk was dismissed. He was referred for a screening and assessment. Have you had a chance to review the report with him? And are there?
I think I threw the same one up there again. I did. I doubled it. All right, so here we go. We're gonna throw on one more, and then we're gonna jump out of here. Here's another Judge McNally.
Yeah, Paul James Pernicano, 25B82401.
I'm glad I paid attention to that, or we'd watch the same one again.
Name?
Paul James Pernicano.
You have a 3-count charge here: animal violation, vicious act, dog at large, no dog license. You have the right to a lawyer. You want a lawyer?
No, sir. No, Your Honor. And I do apologize for my phone going off. First thing I did is turned it off. Yes, I'm sorry.
On December 28 or 24, it is alleged that you did have a dog on. No dog license is count 1, civil infraction. Dog roaming at large is count 2, civil infraction. And 3, count 3 is a vicious act, dog on dog attack. It says that is a misdemeanor, punishable by up to $500 in fines, 90 days jail, costs, or all of those. You understand that?
Yes, Your Honor.
All right, so I'm gonna go ahead and enter a not guilty plea.
Thank you.
What kind of a dog is that?
German Shepherd.
Does anybody else live in the home with you?
No.
$500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. There's to be no contact with the owner of the other dog or prosecution witnesses. You cannot write, phone, see, text, email, or communicate with him or them or have anybody else do any of those things for you. Right? Fenced in yard or on a leash, accompanied by you, but also equipped with a muzzle. Do you understand that? Yep. Do you understand that?
Yes.
That's a condition of your bond. House, fenced in yard, muzzle, accompanied by you on a leash. One of those three things. You understand that?
Yes.
And I can tell you.
My dog guilty before.
Pardon?
You're making my dog guilty of this offense before.
Really?
Yes, because he's not a vicious dog by far. You don't know the situation, Your Honor. You do not. And it's unfair. Those people that actually
slow down.
The people that
slow down.
Sorry. The people that
slow down. It's my turn to talk.
Thank you.
They don't pay me enough to argue with people. Let's hang on a second. I want to make clear that you understand this. I do not argue with people.
I'm not arguing.
And they're not going to argue with me. And if you think I'm unfair, go out in the hallway, tell people, go on Facebook, go out in the parking lot, tell whoever you want, whatever you want, whenever you want. I could care less. You understand?
Yes.
This is a condition of bond. There's not a judge worth 14 cents in the country that wouldn't order this based on the little information that I have. So if you think it's unfair, that's too bad. I could care less. If I find out you're not complying with the bond conditions, we're going to have a big problem, you and me. Do we understand that?
Yes, Your Honor.
Good. If you decide you want a lawyer going forward, you can fill out a petition for one if you can't afford one. If you can afford one, you'll have to hire your own. But I'm not about to argue with somebody about a bond condition that is so customary and so common in these types of cases. You got it?
Fair enough, Your Honor.
When they quadruple my salary, maybe, just maybe, I'll argue with people, but not until.
I appreciate it.
Good. Give me a pretrial date, Lisa.
February 12th at 10.
February 12th at 10. Give them a copy of the bond sheet. Give them a copy of the notice. Again, if you decide that you want to hire a lawyer, you can. If you decide that you can't afford one and want one, then you can fill out a petition for one. Good luck.
Thank you, Your Honor.
So we have, just for the record, I don't know if you saw it, Ms. Foley Carter. We got 2 counts of dog roaming at large, 2 counts of no dog licenses to each defendant.
Correct, Your Honor.
I had told your name, sir?
James Robert.
Ma'am, your name?
Candace Leslie Langmeyer.
I had told them before that I wanted the dog to remain in the house in a fenced-in yard or on a leash, accompanied with a muzzle. He talked about some other thing he had.
It's a fence. It's a GPS fence. That's kind of like the new state of the art.
What do you want to say, Ms. Carter?
Yeah, well, first off, whatever collars he has, if they are fixed with these collars, they're not working. The dogs are in the road, bothering joggers, bothering other people that are walking their dog, defecating on neighbors' property. They are houses down yonder. This has been going on for years now.
I know it has. Ms. Langmeyer was in front of me on a multitude of cases, so much where I actually threatened jail on this because you can't keep letting dogs run around the neighborhood, folks.
If they were out of the yard, we were there with them and they get back in the yard.
I'm just telling you.
I'm just, they don't like run loose. We're there. Now we're there. Now, before my boys would let them out, I don't even let them let them out anymore. I am there. So and that's why I want to see the video. I need to see what there's.
Well, here's what I'm doing.
Larry across the street has been creating issues, not just with me, with every other neighbor. And he's also surveillancing my property.
Hang on a second.
Which is against the law.
Hang on. I just can't believe it's coming to this again. I saw these up today.
I spent thousands of dollars.
Hang on. I just can't believe we are still going on and on about these dogs.
They haven't hurt anybody.
Maybe they haven't. They can't run the neighborhood.
They're not. I'm telling you, if it's one or two times.
Look, I don't know that they were or not on this.
I need to see the evidence,
Yeah,
Your
that's
Honor.
what
I
we
really
need to
do.
see.
I need to see it because as far as I know, they haven't been.
All I know is this. I had multiple cases. I don't know if is this your wife or girlfriend or what. I don't care. But with Ms. Langmeyer, I had multiple cases with her.
Yeah.
Multiple cases with her. So much so that I actually was threatening to send her to jail on dog at large, which I've never done and never threatened anybody about jail, and actually was serious about sending her to jail because I had multiple cases and complaints from neighbors, it sounded like. So now here I am 2 years later back dealing with dog at large cases again. I'm just telling you, I'm going to give you your trial, but just remember, there's no defense to this except the dog it can't be running around the neighborhood. That's dog at large.
I don't know that it has been.
I'm not saying they were.
That's why
I'm just telling you guys, I'm sticking with the bond conditions I just gave you. Dogs to remain in defendant's home, fenced-in yard, or on a leash, accompanied by the owner and equipped with a muzzle. That's it. That's the order of the court. And you're not to have any contact with prosecution witnesses at all. Now, I'm going to give you your jury trial. We'll set it up now if you want. But those dogs, look, I don't know what kind. You told me what they were. Didn't sound overly well. A Mastiff isn't exactly a little dog. Those dogs are huge.
He's a mutt. He's not that big. He's about the same size as our coonhound.
I don't care,
He's 2 years old.
folks. There are laws and you got to comply with them. And I just think it's silly that we've gotten to this point.
It is.
Just please listen. Yeah, but this has been going on for years. Maybe not in the last two. I don't know. I heard you had a case with Judge Heston, didn't you, Ms. Langmeyer, a year or so ago? On one of these?
No.
Are you sure?
I think,
It did, Your Honor.
No.
It was ultimately dismissed and issued against Mr. Adams.
No, I know.
Oh, yeah,
Well, I'm
that's
just
what it was.
saying,
yeah, that's what
I haven't
that's
had
what it
you in
was.
front of me in at least 2 years, probably, Ms. Langmeyer.
And
but-
so it was in front of Judge Heston then in
Yeah.
June of 23. Yeah.
So I'm just telling you that you can't.
If my dogs have done any damages or do anything wrong to anybody,
They don't have the right to run through the neighborhood.
as far as I know, they haven't.
Okay.
That's what I need to know.
They have to prove that. They have to prove it. They
I
have
need to
prove
know
it.
that. I mean, I can't. Larry, the guy across the street's half nuts. He's 80 years old. He's surveillance my property, surveillance in my next door neighbor's
Taking
property.
pictures of the kids.
And then he's actually some of those issues, those tickets. I went. And
How old
looked
are
at
you,
them.
Mr. Adams?
How old am I? 51.
Then you're old enough to know that life is awful short and this is silly stuff. that we're
It's
talking
ridiculous.
about.
It's insanity.
It is. And I tell you what, if my dogs do any damages to anyone, I'll make them whole again.
It's not the point.
You know what I mean?
You can't have dogs running through the
They're
neighborhood.
not,
They
though.
don't run
They're not.
through-
That's what I'm saying is that I don't know that they have. I don't know of any since.
Okay, so she's gonna have to prove her case. I'm gonna give you guys those bond conditions. I expect you to comply with them. I'm gonna give you a pretrial date. You're gonna come back. If you choose to resolve it then, great. If you don't, that's fine. We'll set it for a jury trial, okay?
Yes.
I don't have any problem with that, but just remember, just for whatever it's worth, awful tough for a lawyer to win or for a non-lawyer to win a jury trial. I know everybody thinks this business is easy.
It's not.
It's
No,
not.
easy.
And I'm just telling you, you have every right to represent yourself. I'm not going to deny you that right. You can sit there and play Perry Mason all you want. I'm just telling you, it's awful hard for a non-lawyer to be, you don't know what you're doing, even though you think you do. What day we giving, Lisa? Write it down. February 12th at what time?
10.
And then we'll set it for a jury if it's not resolved. Think about what I'm saying, Mr. Adams.
Yeah.
All I want is the dogs to remain in your yard or in your house or on a leash, accompanied by you or your wife or girlfriend or other suitable owner and equipped with a muzzle. That's what I want. That's what's gonna happen now. What else do you have to say, Ms. Foley
I
Carter?
just want to clarify 2 points about their bond. I know that it said that the dogs need to remain in a fenced-in yard. I know they seem to believe that the invisible fence is sufficient, but it is not.
We have.
I would
we
ask
have
that the dogs
halo
remain on a
collars.
tether or leash at all times.
They have to.
Additionally, for prosecution witnesses, specifically Larry Krasinski, I don't want them to have any contact with him or go back to his home. They did post something on his property after the animal control officer.
Hang on a second. Let's take one thing at a time. You just got done telling me, Mr. Adams, I thought, please correct me, did you not say that that doesn't always work? The fence, the invisible fence?
We got.
No, it's the wireless ones that you put in the ground.
That's why we got them these halo.
That's why I got them the halo ones.
GPS collars.
So the one.
Well, it must
the
not
wire
be
breaks.
working, or at least if you had it, listen to me.
I couldn't.
If you had it November 24th, the dog would have got out of the yard. Right? If it was working. If they think that the dog was out of the yard on November 24th.
I want to see if maybe my kids let them out and they didn't put the collars on them. They don't wear them 24
Only your
hours.
kids. I've heard this story about your kids.
13 and
before.
16 now.
Well, they
13 to
need
16
to
now.
be trained.
Yeah.
I want, no, that dog has to either be in a cyclone fenced yard, in your house, or on a leash equipped with a muzzle and accompanied by you or another suitable adult.
Correct.
That's it.
Okay.
I'll see you guys here on the what are we doing, the 12th at what time, Lisa?
10.
12th at 10. Will you write that on those files, please, Lisa? I gotta,
Judge,
February 12th?
February 12th. And if we don't resolve it then, we'll set it for a jury trial.
Okay.
But you guys, I would encourage you to try to get together. Wait a minute. What else did you mention? You don't want him to have any contact with who?
Larry Krasinski, and not to return to his home.
Yana, can you read this?
Wait a minute. What's Larry Krasinski have?
He's surveillancing my property.
Wait a minute.
He is the.
Wait a minute. Slow down. Was he the one that made the complaint about the dog being at large?
He is, Your Honor.
Okay. Well, that's okay. That's fair. No contact with Larry Krasinski then. I think that's fair.
Yeah.
You don't want to have
We'll just put
contact
this.
with him anyway.
No.
Yeah, but I did write him a letter. That was what I was supposed to do.
You already sent it.
Well,
Yes.
I walked it over there,
Well,
knocked
we
on
did
the door to hand it to
To
him. when
hand
he
it
was
to
home.
him. That's what we did.
What day was that? I have it written down. 12/30/2024.
12:30. And then,
Well, that isn't a bond violation. You've already done that.
Correct.
I didn't
Yes.
have that bond in effect then.
Correct.
Now I do. So now you can't deliver any more letters or call them or write them or see them or text them.
That's all we had to do.
that was what we were supposed to by law.
Come on, guys. Let's get this in order, please.
Yes, sir.
We'll see you here in a couple of weeks. Have a great day.
Yes,
Go
sir.
down the hall, get your notice. Thank you.
Thank you.
Do I have?
All right, everybody. I think that's it for tonight. Yep, it's about that time. Kathy should be on in just a few hours, 4:30 Eastern time, maybe sometime around there. Anyways, everybody, you guys have a great night. We're going to get out of here. Y'all have a good night.